I be allowed to finish my manifestation?
don't
I will
think-
not disrespect and interrupt the defense counsel
Yes, but before
once he
that,
has started.
This is no disrespect, sir.
Counsel for respondent is recognized.
Thank you, Your Honor. Your Honor, this is improper. The improper for trial. Manifestation. This is not a manifestation proper for court procedure. This is instead them telling a story. This is a narration by the prosecution, which is not allowed. This is not allowed by any rule in any court. So what,
May I be allowed
what is
to reply?
proper is that they present their first witness, and
We
are
will be
ready.
presenting our witness, Your Honor. However, please allow us to freely advocate our position.
That's why, Your Honor,
including
we are
the defense
objecting.
when it's their turn. We will not
Counsel
object to the
respondent,
same.
kindly let him finish.
Thank you, Your Honor.
Thank
to
you so
respond
much,
to
Your
you.
Honor.
To respond to you. Yes, you were saying.
Thank you,
Honorable
Honorable
Defensor.
Senator Judges. Noong ikadalawampu
No,
dalawa
Honorable Defensor, kindly finish your reply to the
Thank you, Your Honor.
objection of
I will
counsel
proceed.
for respondent.
allow us to freely advocate our positions through the proper and respectful discourse. This is not prohibited under the rules. In fact, the court has declared that yesterday, the rules will not comply with the strict procedures of a judicial proceeding. Each article is a separate complaint, and it would be the proper guidance for the senator judges, lalo na po sa ating mga kapwa Pilipino na nanonood, para mas lalo nilang maunawaan ang ipipresenta naming ebidensya. The impeachment is a sui generis. Sui generis dahil kakaiba ito, hindi ito judicial, administrative, o civil o criminal proceeding. Hayaan niyo po kaming magbigyan ng 5 minuto para mailatag namin kung paano namin maipresenta at ang basihan namin sa pagpresenta ng aming ebidensya.
Your Honor, may I respond?
The presiding officer should rule. Although indeed we will interpret the rules liberally, and although indeed this is a sui generis proceeding, neither will we allow any dilatory moves and or tactics, and I will bind and hold you to your 5 minutes, Honorable Defensor.
Absolutely,
And we
Your
will
Honor.
clock it.
Your Honor,
we will
may-
afford the same opportunity to the counsel for respondents when their turn arrives.
Thank you, Your Honor.
Your Honor, we move to strike that opening statement. It's improper for trial. It is not evidentiary in nature. And it only provides conclusions of fact and law. Most of it is irrelevant. And fact of the matter is the prosecution should present evidence and not manifest in this improper manner.
May I be recognized, Your Honor?
No need. Motion is denied. Let it remain in the records and as instructed by the chair for the senator judges not to consider, deem whatever statements were given by the Honorable Defensor as evidentiary in any way, shape, size, or form. Again, counsel, call your first witness.
Your Honor, may I request
I-
permission to
Your Honor-
recognize counsel for the panel of prosecutors, Attorney Virgil Ligutan, to conduct the examination of our first witness.
Your
He
Honor,
will be
may I-
under the direct
Counsel
suspension
for
and control
respondent, what is your pleasure?
of
Your
the
Honor,
panel
may
of
I
prosecutors.
register my continuing objection to the opening statement by the prosecution.
Well, I don't think he'll do it again, but nevertheless, so noted.
Thank you, Your
Thank
Honor.
you. Your Honor, may I
Decision passed.
Your Honor, may we move for the exclusion of Agent Kalilong for being not previously attached to the Sabalya and Cabrera complaints, as well as exclusion on the ground that he was not included in the articles of impeachment transmitted to the Senate Impeachment Court.
Can I respond to that, Your Honor, please?
Counsel for prosecutor may do so.
Mga kababayan, in this stage of the proceedings, the prosecution is about to present a witness, and the defense is invoking the facts that this witness is not listed as one of the witnesses in the Sabalya complaint. The Sabalya complaint already lived its natural life. Your Honor, this is the impeachment proceeding of the articles of impeachment filed by the House of Representatives. Sabalya et al. Is done. That should not be a proper objection, Your Honor, please. As to the number 2, I think the good counsel mentioned that it is not part, this witness is not part of the articles of impeachment. Your Honor, please, I have been practicing for quite some time. I don't see that.
Your Honor, may I allow to reply also?
Can I finish? It's not a ground. And in fact, Your Honor, please, to settle the matter, this witness is listed in the pre-trial order. The issue is settled. The issue is passé. No ground for objection. Let me proceed, Your Honor.
Of course not, Your Honor. There were no rulings.
Counsel
in the-
for respondent is recognized
Thank you,
for
Your
a final rebuttal on this issue before the chair will issue a ruling.
Your Honor, there were no rulings on the pretrial order on exclusion of witnesses. We have a current petition with the Supreme Court questioning the very actions of the prosecution to allow the presentation of evidence that were not attached to the Sabaya or Cabrera impeachment complaints would allow the House of Representatives and the prosecution to circumvent the very procedural abuse condemned in Stonehill versus Jokno and allow the violation of the respondent's constitutional rights as held in Duterte in the House versus the House of Representatives. Your Honor, the prosecution says the Sabaya complaints have lived their and they died their natural deaths. However, Your Honor, this precisely does not cure what the prosecution did. This does not cure the violation of the rights of my client.
If I may, Your Honor, please. We
The
move
chair will
forward.
make its ruling. The motion to exclude by the counsel for respondent is hereby denied. Chair cites Enrile versus Sandigan Bayan, which states that the prosecutors may add or rely on evidence during pre-trial even if the evidence is not stated in the complaint or articles because only a summary is required to be stated in the articles of impeachment in this case and or complaint and not a complete list of the prosecution's evidence and or witnesses. The court in general will not shackle the prosecution by limiting it to the evidence mentioned in the information and or the articles, especially when it is mentioned in the pre-trial brief, not only order but brief of the counsel for prosecutors. But in relation to this witness, even if you will do cross, you can register your continuing objection, counsel for respondent.
Your Honor, we note that the Exhibit P-I-U-8 is not an original or certified true copy, and we object to the introduction of this and the identification of this.
What does counsel for the prosecution say?
Again, I reiterate, if it is a printout of an electronic document, the rules are clear, that is an original, Your Honor. Please.
Your Honor, if you look at it, there's on the bottom left-hand portion, there is a mark, certified true copy. This certified true copy would not have appeared in any correspondence with no reply at records.facebook.com. So it is not a printout. It's not an original. Would not reflect what accurately was printed out or appeared on the screen.
2
What does
points.
counsel for the prosecutor say?
2 points, Your Honor, please. Settled now, 2019, assuming that the counsel is correct. Photocopy now is considered as an original, Your Honor, please. And number 2, Your Honor, please. With all due respect, presentation of evidence, objection to the admissibility of object and documentary evidence happens when the documents are formally offered in evidence. We are just in the process, Your Honor, please, of presenting this evidence. So therefore, the defense may object thereto when we formally offer the exhibit, Your Honor, please, and that's not happening yet.
Your Honor,
As a last point, counsel for respondent,
Thank you,
before
Your
the chair makes a ruling.
Your Honor, true that photocopies are now considered originals. However, the photocopy must be an accurate and exact reproduction of that original or that printout. This, Your Honor, may I read it for the record? In the bottom left-hand copy, it says certified true copy, NBI-cybercrime, signed Safira T, date 4/10/26. Is counsel for the prosecution telling us now that this marking came from Meta, the email of Meta, of Facebook?
Again,
Can you respond, counsel, before the chair makes a ruling? I'm interested to hear your response as well.
I'm so sorry. Could you repeat the question, please?
It was rhetorical, Your Honor. He need not answer.
He was basically questioning the fact that if it indeed came from Meta and is a computer printout, why the need for someone to certify it as a true copy?
I do recall, Your Honor, please, that was submitted to the Committee on Justice. Along the way, there was a need to certify that, Your Honor, please. But be that as it may, certification of a printout of an electronic document is not even necessary, Your Honor, please.
The objection of the counsel for respondent is overruled. With the counsel may proceed.
Thank you so
Your Honor, we object to the introduction of this affidavit of authentication. This is not an original copy of his affidavit. This is not electronic evidence. And if you look at the affidavit, even the appendages, which supposedly consist of USBs and CD, there's no USB, there's no CD, and even the signatures are not wet signatures, Your Honor.
What
If
is
I may,
counsel for the
Your Honor,
prosecution
please,
say?
we will not comment to that, subject to the proper response to that when the time comes in the formal offer of exhibit, Your Honor, please.
Your Honor,
The objection of the counsel for respondent is noted as to the admissibility of the offered document. However, as correctly pointed out by counsel for the prosecution, the proper time to object to the same and for the court to rule on it would be during formal offer once the prosecution has already rested its case. So ordered.
Thank you so much. Kung yung flash drive ipapakita sa iyo, will you be able to identify the same?
objection,
Yes,
Your
sir.
Honor. We
Oh.
object.
What is the objection of the counsel for
The
respondent?
document identified by the by the witness was the photocopy, and the appended there's no flash drive, CD, or anything appended upon that. So there's nothing, no foundation for this question.
I have to reply to that, Your Honor, please. This is
And
a
reply, counsel for the prosecution.
This is a non-issue. I asked the witness what did he do after saving the video, and he said he saved it in a flash drive without referring to any document attached to the affidavit of authentication. Basis is laid, Your Honor, please. This is a non-issue. We may proceed, Your Honor, please.
Your
Besides,
Honor,
counsel,
may I
counsel
respond?
for the respondent. This is not a surprise. This was flash drives. Several flash drives were pre-marked during the pre-trial.
Your Honor, may I
conference.
reply first before?
I believe 7 on the part of the prosecution and several on the part of the respondent too. But you may proceed, sir.
Your
Please.
Honor, that is not my objection. My objection is the very basis upon which the witness introduced this flash drive was the affidavit. The affidavit. And there was no affidavit upon the there was no attachment upon the affidavit which they introduced. So the very questions that he has do not have any foundation.
No. Can I
Counsel for the prosecution.
Your
Before
Honor,
the court,
please.
the presiding officer makes a ruling.
Ako yung magiging parang sirang ano. You know, I just said that this witness said that he saved a copy of that video in a flash drive. So the logical question now is to ask him if this flash drive is presented to him, is he able to explain and or identify the same? I don't see any proper basis for the objection to that, Your Honor, please.
Presiding officer will make a ruling. Objection is overruled. The prosecution, counsel for the prosecution, is trying to comply with the requirements enunciated by the Supreme Court insofar as such pieces of evidence is concerned. Number 1, establishing its origin. Number 2, to trace the chain of custody insofar as the transfer to a storage device is concerned. And finally, how it reached this court. So the objection is overruled.
Thank you so
Witness may
much,
answer.
Your Honor, please. Your Honor, please. 2 minutes and 18 seconds of a 2-hour, 26-minute, and 10-second video, Your Honor, please.
Your
What does
Honor,
counsel for respondent say?
we object. Based on Your Honor, based on the rules, part of a video documentary must be presented. Your Honor.
Come again.
I'm sorry, counsel?
Yeah.
Hold on, Your Honor.
I'm sorry, counsel? I did not get what you
Hold
said.
on, Your Honor. Your Honor, under Rule 132, when part of a transaction, writing, or record given in evidence, the remainder must be shown. When part of an act, declaration, conversation, writing, or record is given in evidence by one party, the whole of the same subject may be inquired into. And when a detached act, declaration, conversation, writing, or record is given in evidence, any other act, declaration, conversation, or record necessary to its understanding must be given into evidence. Your Honor, we request that the entire video be played.
Your Honor, can I respond to that, Your Honor, please? Can I respond to that?
What does the counsel for the prosecution say before the chair makes a ruling?
Your Honor, please, we don't want to put the defense on the spot, but that is a misreading of the rules. Your Honor, please, counsel cited Rule 132, Section 17. With all respect to the defense, that doesn't serve your interest. It serves the interest of the prosecution. May I explain? Reason. If we read Section 17 of Rule 132, it says, when part of transaction, writing, or record given in evidence, the remainder is admissible. When parts of an act, declaration, conversation, writing, or record, when part is given by one party, and in this case, that is the prosecution, the whole of the same may be inquired into by the other side. Meaning, it's simple. This rule, Section 17, Rule 132, allows exactly the prosecution to present a 2-minute portion of a 2-hour video subject to the defense, the presentation of the remainder of the same. Be that as it may, Your Honor, please, the rules are clear. Number 2, we invoke, Your Honor, please, the ruling that it is for the prosecution to decide what to present, when to present, how to present, and whether to present at all. Be that as it may, Your Honor, please, the defense will not be prejudiced exactly because when the time comes for the defense to present their evidence, they can present the remainder of that 2-hour video. What we are saying, Your Honor, please, for the interest of time, for the prosecution's presentation of evidence, we deem that's only a 2-minute portion of that 2-hour video is relevant at this point in time. Your Honor, please, we move for a ruling.
Your Honor, if I may respond.
As a last response,
Your Honor,
counsel for the respondent.
The prosecution cannot be allowed to present a truncated part of a whole 2-hour, 26-minute video. That will not provide the context necessary for the understanding of what occurred during that night on November 23, and also not allow the proper identification by this witness.
Your Honor, sorry, I will not even reply to that, Your Honor, please.
Chair would like to ask, who did the edit from the how many hours? 2 hours.
No. Your Honor, please, if I may, can I
From the
reply to that?
total, who did the edit? Was the witness the one who did the edit, or was it already the prosecution?
Your Honor, there's no editing done. There's no editing done.
Who got that shorter portion?
No, Your Honor, please. What we are presenting are portions of the entire 2-hour video. And this witness, I think, will be able to identify the specific timestamps of that preserved, not edited portion. If I may repeat, Your Honor, please, we are not presenting any edited portions, but only snippets, portions of that 2-hour video. And this witness, I suppose, will be able to identify which specific portions that he would like the court to view at this point.
So when it is shown, the witness will testify and attest to the portion of the entire video that it was found insofar as the timestamp is concerned.
Yes, Your Honor, please.
But as evidence, at the proper time, you will be offering this entire
Yes.
2-hour or so video.
Yes, Your Honor, please.
And simply highlighting
Yes.
the 2 or so minutes. Would that be correct?
That's a very keen observation. Agree 100%, Your Honor, please.
Your Honor, the prosecution cannot be allowed to do this because the entire video will show the context on which the utterances were made.
That is a matter for the counsel for respondent to do and present during their time, because I believe the counsel for respondent also identified and marked, if I'm not mistaken, the same video for over 2.5 hours. It can do so during its time to present its evidence in chief.
Thank you so much.
The objection is overruled. Counsel is instructed to go to the booth accompanied by a counsel from the respondent in order to make sure that indeed the USB identified by the witness is the same USB that will be played in the tech booth of the Senate.
Okay. Tips.
Are you done?
Objection?
Objection, Your Honor.
Wow.
Kindly state the objection, counsel for response.
Your Honor, the question is misleading. There was no mention anywhere before that that the video mentioned that the killing of the president.
To kill.
Yeah, there's no mention in any testimony earlier. There's no mention that that video.
Your Honor, again, with all respect, the records will bear me out. Bases have been more than complied with. This witness mentioned many times over that the subject of the investigation is the statement of the Vice President that she already contracted a person to kill the President, the First Lady, and the former Speaker. There's no basis for the objection, Your Honor, please.
Your Honor, may I ask for a readback? He was the only party who said that, Your Honor, not
Kindly
the...
use the third party in referring to opposing counsel.
Yes, Your Honor.
If I may, Your Honor.
May I ask, Your Honor, for a...
Let the counsel for defense finish his statement.
May I ask, Your Honor, for a reading of the transcript, as the witness, to my recollection, never mentioned that the Vice President did those things.
All right. If I may, Your Honor, please.
Counsel, kindly lay the basis.
Yes, Your Honor, please. Now, Mr. Witness, you said that your office, the NBI, conducted an investigation for a statement made by the Vice President noong Nobyembre 23, taong 2024. Naalala mo yun?
Objection, Your Honor.
Oh. Your Honor, please.
What is the basis of the objection?
Your Honor, it's leading.
Your Honor, please. If I may, Your Honor, please.
Do you remember? Leading, Your Honor.
If I may, Your Honor, please, I'm just giving into what the defense wants. The record will bear me out. This witness mentioned so many times over that he investigated the statement of the Vice President uttering that she already contracted a person. The whole nation is listening.
The chair will
Your
make
Honor,
a ruling.
so
The
many
objection-
words leading.
The chair will make a ruling. The objection is overruled. Earlier, chair noted, I have it in my notes, that the question was propounded by counsel with respect to the 11/23/24 incident that was the subject matter of a digital forensic examination by the witness pertaining to the former Vice President. That was the instance, if the counsel will recall, that counsel for the prosecutors asked the witness if he knew who the Vice President was. So the objection is overruled. Witness may answer.
Your Honor, may I state for the record, my objection is on the part of the question where he said that the Vice President hired someone to kill the President, the First Lady, and the Speaker of the House, not on the identification of the Vice President.
Noted. Court already made a ruling. Witness will answer.
Mr. Witness, naalala mo ba yung tanong?
Can you repeat the question,
Okay,
sir?
now.
Kindly repeat the question, counsel.
In what particular portion of the subject video in that online media conference of the Vice President did she utter that she already contracted a person to kill the President, the First Lady, the former Speaker? In what portion?
Objection, Your Honor.
What
Sir,
is the objection?
Your Honor, this honorable court already ruled on this question. The discussion later on was on the leading question made by the prosecutor. If you recall, Your Honor, this honorable court said, prosecutor, please lay the foundation, the basis for your question.
Your Honor, please, if I make a response.
The presiding officer will ask the witness. Mr. Witness, out of the 2 or more so hours of video that you downloaded, do you know, if at all, the timestamp that pertains to any statements made by the Vice President pertaining to any of the allegations in the articles of impeachment, particularly Article 4, the subject matter of this case, in relation to alleged threats made by her in that video? For the prosecutors, may proceed.
This will be quick. Mr. Witness, you said that your office conducted an investigation on the statement made by the Vice President dated November 23, 2024, correct?
Objection, Your Honor. Leading.
Your Honor.
Your Honor, he's not on direct. He's
Overruled. Witness may answer.
Yes, sir.
Now, tanong, ano ba exactly yung sinabi ng Vice President nung araw na yan, November 23, 2024?
Objection, Your Honor.
Well,
Vague.
I'm not yet done.
Well, Your
please.
Honor, the pauses of the prosecution are very
Kindly
confusing.
let the counsel for the prosecutors finish his question
Precisely,
before you
Your Honor.
object.
May I
Counsel
ask
for the prosecutor
also
may proceed.
may I ask, instead of this, Your Honor, may I ask that the Honorable Court direct the witness to allow me to object before answering? Because
No.
precisely the questioning of the prosecutor
Okay, what?
is there are many pauses, which it's confusing if he's done or not.
Counsel, witness even on occasion forgot what the question was because he did not respond to the question of the prosecutor.
Yes, Your Honor. So I just
Court will make sure of that.
Thank you, Your Honor.
So kindly finish your question if
Yes,
you want
so-
to state it again, counsel for the prosecutors.
Maybe it's the tone, no? I'll be quick. What particular statements of the Vice President on that day did you investigate?
Objection, Your
Oh.
Honor. Vague.
Please.
Take counsel for respondent. A bit of patience. Let the counsel
Yes.
finish. I don't think he's finished.
The question is done. What particular statement on that day did you investigate? How is that leading?
Objection, Your Honor. Vague.
Okay, Your
Not
Honor.
leading.
Your Honor, please. Can I,
I didn't
address
say
to that,
leading.
Your Honor, please? Can I?
What was
Whether-
counsel? What's the basis of the objection?
Vague.
All right. I will
It's a
indulge.
2 hour
Your Honor, please.
36
I will
26
indulge,
minute
Your Honor,
video, Your
please.
Honor.
I will indulge. I will add these two phrases. It will never be. That. Now, Mr. Witness, what statements did the Vice President utter on that day, if any?
Your Honor,
Whoa.
same objection. There's
Honor,
a
please.
2 hour 26 minute. What?
Let the
does he
witness
mean?
answer.
Counsel, this 2 hour and so minute video was done on the same day.
Yes.
Correct, Your Honor, but the question must be given with particularity.
If the witness knows, witness may answer.
Answer.
Witness will please answer.
Can I refer for my notes to identify the exact statement because I might said a statement that's not part of the actual statement.
Presiding officer will allow the witness to refer to his notes to refresh his memory. Go ahead, Mr. Witness.
The specific statement, quote and quote, "Yes, huwag kang mag-alala ma'am sa security ko kasi may kinausap na ako na tao. Sinabi ko sa kanya, kapag pinatay ako, patayin mo si BBM, si Lisa Araneta at si Martin Romualdez. No joke, no joke. Nagbilin na ako ma'am. Pag namatay ako, sabi ko, huwag kang tumigil hanggat di mo sila mapatay. Hanggat di mo sila mapatay sila. And then he said yes."
Please proceed, counsel.
Thank you. Now, in what particular portion of that video recording that you authenticated of that online media briefing on November 23, 2024, did the Vice President utter those words?
If I may, sir, I think we should include the question first. It start at 1 hour and 15 minutes to 1 hour 17 minutes and 18 seconds, sir.
Your Honor, so the witness manifested as an answer to the question in what portion he said, timestamps 1 hour 15 minutes 0 second to 1 hour 17 minutes 18 seconds, and we computed, Your Honor, please, it's a 2-minute 18-second portion of that video. At this juncture, Your Honor, please, bases have been laid. The nation can finally see it. The court will do. We move that's 2-minute and 18-second portion of that video be presented at this juncture, Your Honor, please.
The Secretariat is instructed to play the USB given to the tech behind that was observed and witnessed by both counsels for the parties. Ordered.
Your Honor, same objections to this printout. Yes.
May I know the specific
Your Honor, same
objection?
objections. There is on the left, right bottom portion of the Annex P-U-12, 12A, and until 12B. There are marked certified true copies from the NBI signed Safira T, dated 4/10/26, Your Honor.
Court made the previous ruling about this matter already, but the objection is duly noted.
We submit, Your Honor.
Thank you.
Your Honor, we move to strike the manifestation. He's already testifying on behalf of the witness.
Your Honor, we cannot move to strike a manifestation of counsel. The good counsel could do his own manifestation. That's not in the rules.
I would like the Honorable Court to rule, Your Honor.
Motion is denied. Let it stay and remain in the records in response to the query of Senator Judge Erwin Tulfo. Senator.
Ano ba yung nangyari? Ano ba yung nangyari kung meron man pagkatapos ng naging investigasyon ng NBI?
Objection, Your Honor. Misleading. He assumes as fact not testified to by the witness.
Kindly rephrase, counsel.
Okay, now, what happened next, if any, and if you know, and in relation to the investigation conducted by the NBI, after the NBI's investigation?
Objection, Your Honor.
Your Honor.
Same objection.
Your Honor, please, if I may...
Witness may answer.